Hi, I'm Greg Corombos. My guest at this time is Andrew C. McCarthy, former Chief Assistant U.S. Attorney in the Southern District of New York. He is now a contributing editor and columnist at National Review Online and a Fox News contributor. We want to get his thoughts on a pair of important legal subjects today, starting with Monday's Supreme Court ruling that jury convictions in criminal trials must be unanimous. We also want to get his thoughts on many localities releasing prisoners in efforts to mitigate the spread of coronavirus. And unsurprisingly, some of those released prisoners are committing crimes once again, and some of them are violent. And Andy, thanks so much for being with us.
Greg, it's my pleasure.
Well, let's start with the Supreme Court decision today. And this was a 6-3 split, and not along the usual lines. We'll talk about that a little bit later. But here is a portion of the majority opinion from Justice Neil Gorsuch on the need for unanimous jury verdicts in criminal trials. He says, "Wherever we may look to determine what the term trial by an impartial jury trial meant at the time of the Sixth Amendment's adoption, whether it's the common law, state practices in the founding era, or opinions and treatises written soon afterward, the answer is unmistakable. A jury must reach a unanimous verdict in order to convict." And so, Andy, I think that's very important, since I quickly looked up the Bill of Rights again and saw that there is obviously a provision for an impartial jury trial. It does not specifically say that the verdict has to be unanimous, although I think that's the assumption most Americans, both then and now, would carry, since dissenting jurors would probably qualify as reasonable doubt. What do you make of today's verdict?
Greg, any of us who've seen 12 Angry Men must be wondering why this was a case at all. Of course you need unanimity. Otherwise, what was Henry Fonda doing for 2 hours? But it's interesting. We often talk about trials, but the trial, the Western concept of a trial is something that goes back centuries, and it has certain underlying assumptions about it. I remember during the time of coerced interrogations, the enhanced interrogations that the Bush administration authorized after 9/11, there was the big issue about whether there had to be a treaty or some tweaking of a treaty that existed to determine whether, or to conclusively say that those that statements that were derived from coercion could not be used against the people who made the statements. And I remember arguing at the time, and I was somebody who argued that the way that they were practicing the coercion did not meet the standard of torture. But I argued that the reason that you would keep these statements out is because it would be repulsive to what the Western concept of a trial is, to allow in evidence that a person was required to provide against himself. And unanimity of the jury verdict is along these same lines. It's just a basic element of what the criminal trial is. And one of the big issues before the court is, why were these two states that are involved in this case, Louisiana and Oregon, why did they have a different standard that allowed convictions 10-2? In this case, a guy was looking at basically the rest of his life in prison, a guy named Ramos, over being convicted in a criminal case in Louisiana. How did this outlier status get rolling? And the answer is noxious. It turns out that in order to try to water down the power or the rights of African Americans and other minorities, but mainly African Americans, under Jim Crow and all kinds of other noxious provisions during the Reconstruction era, these states watered down what they previously had on the books, which was the common requirement of unanimous juries. And the idea was to reduce the influence of Black people and other minorities on juries. So it was specifically intended for a really reprehensible purpose. Now, it should be, I hasten to add here, as Justice Gorsuch did in his opinion, those states, to their credit, have not only rejected the underpinnings of this outlier rule that they had, they were emphatic in telling the court that that is not the reason anymore that they abide by this unusual rule. I happen to think the reason that they abide by it, namely to reduce the possibility of a hung jury, is not a very good reason, but at least it's not the racially invidious reason that was the original underpinning of this very different rule.
So as I mentioned at the outset, Andy, it's not your typical breakdown on the Supreme Court verdict. The three justices in dissent were the Chief Justice, John Roberts, along with Sam Alito and Elena Kagan. So what was their argument for keeping it the way it was?
It was based on stare decisis, which is the doctrine of law that basically honors precedent. It basically says that we stick with prior decisions in order to support predictability in the law, which is very important. Even occasionally, if the decision that we're sticking to was incorrectly decided, because if something that's been incorrectly decided has nonetheless been on the books for a long time and people have started to make their arrangements around it, they've relied on it, the disruption that you can get from correcting the decision can be worse than the error. At least that's the theory behind it. And it's a theory, Greg, that's followed less in constitutional cases than statutory cases. And in statutory cases, the president and Congress can always change the law if the court does something that's incorrect. But in constitutional decisions, it's very hard to change an incorrect ruling by the Supreme Court. So they have to be open to revisiting those rulings. And indeed, if they didn't, a terrible decision like Plessy versus Ferguson, which upheld separate but equal education facilities, would still be the law. Dred Scott would still be the law if the Supreme Court didn't reverse itself. So obviously, it has to be willing to revisit incorrect decisions. The question always is this kind of fuzzy area of which precedents are so importantly wrong that we need to reverse them, and which should we keep even though they're wrong, because the upheaval would be worse than keeping the mistake. So they were leaning, the three dissenters were leaning on this idea that this case called Apodaca, which the Supreme Court decided in 1972, which upheld these non-unanimous verdicts, even though the reasoning of the decision was so screwy that it's hard to figure out exactly what the court's ruling was, other than that they upheld a judgment of the state courts. They decided that precedent has been on the books since 1972, so we should hold on to it. The rest of the court was not persuaded that was the case.
Real quick practical application here, Andy. Does this mean that everyone who was sent to prison with at least one vote for acquittal gets freed now? Do they get a new trial? What happens?
Yeah, they get a new trial. What'll probably happen, Greg, one of the things that Justice Gorsuch, I think, was very persuasive on here, the argument you just made is exactly what the dissenters were saying, which is we're throwing these two legal systems in these two states into chaos. And the answer to that, as Gorsuch explained, is, number one, we're not talking about all that many cases. But number two, we're only talking about two states. There are a lot of times when the courts have made decisions in criminal justice cases which completely change our operating assumptions at the federal and state level throughout the country of rules and procedures of criminal justice. And yet the court has said, we have to make these decisions because these are constitutional rights and they have to be vindicated, even if it means disrupting the entire country. Here we were talking about disrupting two states. What'll probably happen is the cases will get, pled out, or they'll have to retry some cases. And the court was pretty clear that it really will only affect cases that are on what's known as direct appeal. In other words, if you're still in the pipeline for having your first appeal, you can use this new ruling. If you were convicted years ago in a 10-2 case, the rule will not more than likely apply to you because you're not on direct appeal anymore.
Andy, exit question on this one, and I'm sure as a lawyer you could go on at length, but real quickly, I saw on Twitter today you said you not only agreed with the ruling, but you said it's almost a pleasure to read Neil Gorsuch's rationale when he writes the majority opinion. So what is it about him that's so compelling?
Oh, he's such a wonderful writer. He's just, a lot of people who are superb lawyers and superb legal technicians who write very good very understandable opinions, just don't write in a gripping way. Gorsuch has this wonderful, engaging prose. It's almost like reading a book. It's like reading literature when he writes, and I think it's fitting that he is the replacement for Justice Scalia, who was the finest writer of his generation. So Gorsuch is clearly a fitting replacement.
All right, let's move on to our other issue now. And as I mentioned, and I'm sure many of our listeners already know, certain localities, particularly big cities, have decided that they are releasing some of their prisoners early in order to try and mitigate the spread of the coronavirus in lockups. And one of those cities is New York, which, of course, is the hardest hit metropolitan area in the country. And it turns out that, according to the New York Post, some folks who were released from Rikers Island actually ended up committing new crimes. And the mayor of New York City, Bill de Blasio, says it's unconscionable that folks who were shown mercy and that this is what some of them have done. It's just truly horrifying for him. He says we haven't seen a ton of recidivism, but he says any is too much. I know you and I have talked about criminal justice issues in the past and what's appropriate for locking folks up. So what do you make of the idea of letting folks go home early because of coronavirus and the fact that people would be shocked that some of them would commit more crime?
Yeah, I think it's fitting that it's de Blasio, right? Because the last time he was seen outside City Hall or outside his gym in Brooklyn was when he was over at Rikers Island throwing the door open for everybody to empty out of the place and scatter. I think with Met tickets to make sure that they made their next court appearances. Heather McDonald put it best, that getting into prison in America, even though the reform movement wants you to believe that the prisons are teeming with nonviolent first offenders, the fact of the matter is jail is like a lifetime achievement award. And most people who are in it, in crime, and most people who are in it are recidivist offenders who really need and deserve to be in prison. And when they're let back out on the street, I'll be darned, they commit more crimes, which absolutely nobody should be surprised by. And you would think that we have more than enough problems right now than the need to deal with the fact that you're going to have people who are sociopaths released back on the streets. I think it's just a very bad idea. And again, Greg, I think we have talked about this aspect of it before. A lot of people who are in jail appear to be in jail on what's ostensibly not so serious crimes. That's often the result of the fact that their crimes that they committed were plugged down to something that would give them less time in jail, but they're such serious offenders that it was felt that they had to do some time in jail. So the idea that we're letting out nonviolent people and not to worry is just it's a fantasy and it's a dangerous one.
So do you believe that what is the right thing to do if officials believe that jails and prisons are a breeding ground for coronavirus? Are there proper steps to take, or is the lesson here, don't find yourself in prison in the first place?
Well, look, the state has a responsibility to maintain safe prisons. Any government system that runs prisons can't run dangerous prisons on the rationale that, this goes to show you better not get yourself locked up. We have a responsibility to maintain responsibly safe prisons. If the congestion in the prison is such that they can't maintain it safe under the coronavirus threat, then they're going to have to let some people out. But I think they have to make a good effort. I mean, social distancing is very hard in a prison, but you have to, the idea that you can say, gee, we have a problem that congestion exacerbates and therefore we have to let everybody out or we have to massively let people out of jail, that's irresponsible too. They have to come up with a happy medium that allows you to keep people who should be in jail in custody, but at the same time maintains their safety. I'm not pretending that it's easy, but it's something that has to be done.
Andy, we'll leave it there and we'll see what happens on both of these fronts. Thank you, sir, very much for your time, as always.
Thanks so much, Greg.
Andrew C. McCarthy, former Chief Assistant U.S. Attorney for the Southern District of New York, contributing editor and columnist at National Review Online. He is also a Fox News Channel contributor. I'm Greg Corombos, reporting for Radio America.